Hi all, Cass Smith here. So we're going to talk today about one of my favourite topics, which is family wealth protection. Why is wealth protection important? Well, I've always believed that if you're going to work really hard and build up some assets during your life, that you want to protect it. You want to protect it during your life and after your life. So a very essential topic. So a little bit about myself, because people watching this may not know of my background. A lot of you may, so sorry to bore you with this, but it's necessary for those that don't know me. So my previous name was Catherine. Well, it's still my name, but that's a long story. But if you want to Google my history, you'll find most of it under Catherine Smith rather than Cass. So I have been around for quite a long time, even though I look so young. I have over 30 years experience in all financial fields and over 20 years experience as an accountant running my own business. So, and I have a large number of degrees and diplomas. I think I spent about 20 years in higher education, and I know that that is indoctrination, but at the time it was necessary for me to get qualified and for me to have my career in all the financial fields. So I have an underlying bachelor's degree in commerce, a master's degree in tax law, advanced diploma of financial planning, a diploma of mortgage broking, a diploma of real estate, a diploma of financial planning, and I'm a Justice of Peace and a recognised taxation specialist and a public accountant. I also went on a bit of a sidetrack and I did a master results coaching, that's with NLP, and I was a tax fraud investigator for 11 years in the tax department. That is an interesting story in itself, which I won't go into in detail today. But I've been an accountant for over 30 years. I used to be a financial planner before 2021. I've been a mortgage broker and a property expert for over 20 years. And more recently, I've qualified as a succession, asset protection and estate planning advisor, SAPIA advisor, SAPEPA advisor. So that was really just bringing, it's not a new skill, it's bringing all of my 30 years experience in accounting, taxation, property, mortgages, finance, trusts, all into one service, which we call SAPEPA, which is Advanced Asset Protection Strategies. So just a little bit about my journey. So as I said, I was in the tax department for 11 years. I won't go into my full story here today, but I saw a lot of corruption and control, and I didn't like it, so I left. After I left, since then, I've been helping clients with all of their financial needs, including setting up businesses, tax minimisation, asset protection, building property portfolios, share portfolios, superannuation portfolios, you name it, for over 20 years. The important bit about all that for today's presentation is that I've had 30 years experience in trusts. I wrote my master's thesis paper on trusts over 20 years ago. And what I wrote my master's thesis paper on hasn't really changed much between now and then, because what I argued in that paper was that the tax office cannot attack trusts in the way they'd like to, because trusts have been around in equity law and common law since the 1600s. So they're a foundational principle in our law. Trusts exist before companies, before partnerships, before all of these other entities that we now have. They were always in existence. So back to my journey. I retired during COVID because I saw my 30 years experience as just a waste of time, because I always knew, but it became even more apparent that the whole financial system is just a sham. It's an illusion. It's based on concepts that don't stack up in logic. The share market in particular is nothing but, someone said to me today, a client confidence measure. So people are buying shares with their client confidence based on the share value. And then the share market can crash, but nothing's changed about the company. It's still the same. It's all just an illusion. And I just realized during COVID that once that illusion pops, the bubble will pop, everything will pop. And what's the point in all my advice? But I'm now back on the front line and working very, very hard, unfortunately, because I do not like working very hard, but I am working very hard because the combination of everything that's happened over the last few years and the combination of what I see coming, which we'll talk about, I now realise that all Australians need very significant advice on asset protection during these times, and they need trust that actually works. And I'll talk more about that. So what we're looking at building is what we call the moat and castle. So like Buckingham Palace and like all of the elites, they have protected their wealth using trust and all sorts of strategies to make sure that nobody can touch it and that their wealth gets handed down from generation to generation without anybody being able to attack it, sue people and get the money with creditors and bankruptcies and things like that, but even more importantly for the next generation. So if they can do it, why can't we? So the issues that I see, or that I've seen for 30 years, is that what happens in the event of a legal suit on your assets, particularly on death or incapacity. Everyone is after your assets. Australia now produces the most amount of lawyers per capita in the world. So even more than the US. We used to be second to the US. Now we're the leading country for lawsuits. So if you own assets in your name, you have a huge target on your back during your lifetime, and even more so after your lifetime, because there are now no-win, no-fee lawyers who are happy to hunt down clients to sue you. Crazy. So assets in your name are a huge mistake. But what's the solution? Because the Australian taxation laws are built to encourage you to hold assets in your own names. So, for example, the capital gains tax exemption on the principal place of residence and the negative gearing benefits for investment properties. So these taxes encourage you by giving you tax exemptions if you hold assets in your own name. But that exposes you to legal cases. Some people have tried to get around these laws by putting assets in their spouse's name, only to find that then they've separated with that spouse and that has caused them an absolute world of pain. So finally, a will and testamentary trust, if you think that all your assets are protected when you die because you have a will and hopefully a will with testamentary trust, it can still be overturned with family provision claims. So they are reasonably new laws that have been introduced whereby any person who feels they've been left out of your will, they can come after your property. So the bloodline problem, well, I shouldn't call it a problem. It's a matter of who wants their assets to be passed down to their bloodline, your own children, your own flesh and blood. Who here doesn't want their assets to go to the tax man? I think everybody would agree to that. Who doesn't want their assets to be lost in a lawsuit? And who here doesn't want their assets to go to the lawyers defending your estate from a lawsuit? Because I could spend all day here citing cases and going through examples of cases where somebody has passed away and a lawyer has come after beneficiaries. That's my dog, sorry, with some beneficiaries that feel they're left out, and they've attacked the estate. And even if they didn't have any official claim on the estate, as in the beneficiary that's trying to get anything, didn't get anything. The judge said no. But you know who got a lot, if not everything? That's the lawyer. So we have seen cases where the estate may have been worth a few $1 million and the few $1 million has gone to the estate lawyer. The average estate case would be costing in the hundreds of thousands, even the most basic estate. And then that money all comes out of the estate. So you can see why lawyers are so hungry to get their hands on that money. So what can you do? Can you pass monies to your children during your life? Probably not. There's many ways around that, particularly under the Family Law Act that says it can claw that back. The bankruptcy laws can claw that back. Most people are also not aware that a 2-year de facto relationship can mean your partner can claim on your property and call it matrimonial property. On death, if the asset goes to the child and then the child dies without any strong bloodline trust, the assets can go to the child's spouse. So I'm talking adult child here. So not only a spouse, it could go to their de facto. So you may think that you have a very strong will and you hand your assets onto your adult child. 2 years later, they get divorced or even just de facto breakup, and half your assets are taken by the spouse. So as I said earlier, on death, a claim can be made against your estate, costing your beneficiaries hundreds and thousands just defending it. And there's also a human element in this. We have, once again, I could cite case after case after case where the mere legal action of the beneficiaries attacking the estate after death causes a family fallout that just destroys families for years to come, if not forever. So you can prevent all of this by utilising some of the strategies we're going to talk about. But wait, there's more. So the background to what I'm going to talk about today is that I was in Fiji with a very large number of, say, about 50, 60 other high-level accountants and lawyers who specialise in estate planning. On the day that the government retreated from their $3 million superannuation tax called Division 296. So what they did, they made a big announcement saying that we are not going to tax unrealised gains anymore. For those that don't know what it was, the government was planning to tax unrealised gains in superannuation funds that were over $3 million. That tax is unheard of. It's never been in Australia before. I don't even know if it's in any other country, because you can't tax unrealised gains without causing a huge amount of problems. The simplest way is to talk about an example. Imagine the family farm. So the most common asset in a self-managed superannuation fund, up until more recently, was the family farm. So let's say the family farm's worth $5 million, and let's say it goes up in value 10% per annum. That is $500,000 per annum. Now let's say the government's going to tax this. So every year, that superannuation fund now gets, let's see, $500,000 gain for the year, not realised, meaning they haven't sold the property. It's just gone up in value. Let's say the tax rate was only 15%. That's $75,000 in tax that farmer now has to pay on his property that he hasn't sold. It's unworkable. Where's that farmer going to get the money from, particularly in today's world where a lot of farmers are absolutely strapped and struggling? So the tax was unworkable. It took 3 years of arguing that before Labor finally retreated and said, oh, we won't do it anymore. Aren't we wonderful? Aren't we fantastic? We're such a good government. We're not going to tax unrealised gains. Good on you. When that announcement came out, as I said, we were sitting in a room in Fiji with 60 other accountants and lawyers, and the announcement came and we all, those that were on our computers, went, oh, they've made an announcement, and we looked at it. And then we actually dedicated that afternoon to having a look at that announcement, and we all concluded the same thing and said, don't be fooled. There were so many red flags and things that didn't add up in that announcement. Firstly, they were calling it a 30%. So they've introduced a tax anyway, just not unrealised gains. They're saying that it'll be 30% on super funds over 3 million and 40% on super funds over 10 million. It's actually a little bit misleading, because super funds at $3 million are already taxed at 15%. And so really it's not a 30% tax, 40% tax. It's an additional 15% and 25%. But they didn't say that. They just kept hammering on about 30% and 40%. We all saw it as a really clever way to get Australians used to those numbers. We all agreed, because the other thing they were saying in their talk was, oh, you know, we've done such a good thing not taxing unrealised gains. But yeah, the problem is we were going to get so many billions of dollars a year in that tax and we've already spent that in our budget. Now we're a bit short on our budget, so we might have to think of some other things. Like we all know, the government they meet for the public servants in Canberra Parliament House, they meet every Friday afternoon for drinks just to invent new taxes. So they made it clear that their budget is now short and they're going to have to come up with something else. So we all agreed in that room that we believe that there will likely very soon in Australia's future be a wealth or a death tax. And this is not unusual. The UK has a death tax. The most modern countries have a death tax, and it happens to be 30% and 40%. So not only is there wealth and death taxes, but we also see, sorry, there's just the slide. UK's 40%, France is 45%, Japan's 55%, and the US is up to 40%. They have slightly different tiers. So, and there are also think groups in Australia that are already thinking really hard about extra taxes and coming up with reports saying to the government, a death tax would be a really good idea. Sorry about that being cut off, but once the door opens to a death tax, we expect a gift tax too. So families can't pass assets down without paying up. And the rationale for that is very, very simple. If they announce next week that there's going to be a death tax starting as of now, but obviously doesn't apply to the dead, everyone that is getting older and starting to die will start thinking about passing down. Everyone will just gift their assets to their beneficiaries if they can before they die. So what they will do on the announcement of the death tax is they'll say, oh, and also a gift tax. So if you gift your money away, you're also caught by the tax. They may wait for a financial crisis, or it may be, I think, potentially in the budget next year in May, because the budget is the night, and I'm a bit of a nerd because I actually watch budget night. Because yes, the media tell you everything you need to know the next day, but I actually find listening to the words that they say on that night often sheds more light than what the media carry on about the next day. So I listen to the budget, and it's in the budget that they can sometimes go, hey, and by the way, as from tonight, there'll be a death tax and a gift tax on all assets. So it may be budget next May, which is why I'm back on the front line working as hard as I can between now and May to try and get as many people as I can into these structures, which I'll talk about in a moment, before May. If not in the budget in May, or maybe sooner, later, when we have the inevitable financial crisis that I've been saying we're going to have, and yes, I've been saying it 3 years, and yes, it hasn't happened yet, but every single day when I open the news, we're one step closer. And as I speak here now, the share market is crashing. There's all sorts of things happening out there on the market. Bitcoin has crashed, gold and silver escalating, share market's wobbling really hard. So any day now we'll have this inevitable financial crisis, or it could be another virus, or it could be a war, it could be anything. And then the government will say, oh, the economy's in a little bit of trouble now. I think we need a fair solution. It's time for a wealth tax, effective immediately. And they are able to do that even if they don't have the legislation ready. They can say, as from tonight, this tax is in place, and then they write the legislation and get it through Senate and everything, but it's backdated to the night they announce it. And they do that in these situations when they're concerned that if there's a lag time, like if they announce it but it's not effective till next year, it gives everybody too much time to plan. So I think when they bring this one in, it will be effective immediately. So that's why this action is so important. Don't wait for Canberra to decide what you're allowed to keep. Now is the time to lock in your structures, look at your super, protect your wealth, because as I started this presentation with, you want your hard-earned wealth to go to your bloodline, to your family, to your children, to whoever you want to leave it to, and not the government. Because once that they announce it, it will be too late. So what is the solution? So what I was in Fiji learning is about the Family Protection Trust strategy. So this is not new. This is not just a brand new concept that we've pulled out of a rabbit out of a hat. It's been around for quite a long time. But as I'll talk about shortly, previously I knew about it, but I really only implemented it for very high net wealth clients who really needed something like this, because maybe they were in a financial situation where they might have a lawsuit, they might have people sue them for something they've done wrong. It might be preventing future family relationship breakups. It may be all that sort of thing. So I personally have always had my assets in a trust. So ever since I made some mistakes when I was younger, everything from that moment on, last 20 years has been, everything I've had is in a trust. And so for similar professionals in my situation, I've put them in trusts. But for the average mum and dad, people may have heard me on other podcasts say, no, you don't need your family home in a trust. You don't need all that complicated structures. As I said, I've been a specialist in trust for 30 years, writing my thesis paper on it over 20 years. And I have used trust for businesses, for investment properties, for all sorts of things, but not necessarily for your own home until now. Now it's these impending death taxes that have now convinced me that everyone needs this. So the Family Protection Trust is designed to protect your personal net wealth during your lifetime. So I also may refer to it sometimes as a living trust. So if we think about concepts of trust, we use trusts for businesses. They're often family discretionary trusts or unit trusts. We have testamentary trusts for after you die. A living trust is the one in the middle. It's not for your business assets, it's for your personal assets, and it's while you're alive, not when you pass. So the Family Protection Trust is set up to have only your bloodline as beneficiaries, including any trusts or companies that they may belong to. We establish your Family Protection Trust, and then we gift your net worth to the trust through a deed of gift backed by a note. This is the point that I will repeat quite a few times to make sure you fully understand. The benefit of this is there's no capital gains tax or stamp duty. I previously resisted transferring people's personal assets into a trust because of the capital gains and stamp duty. In this case, there is none. The amount which is gifted, which is called the capital of the Family Protection Trust, is lent back with minimal interest rates repayable at the end of the loan or when you die. And the loan is secured by registering a mortgage over any property you own. So that's the complications behind it, the basic structure, and that you don't have to worry about that too much. That's what we do for you. But just to put it in a little bit of a picture, so it's called the Protector, the Family Protection Trust. So you gift all of your assets, cars, shares, watches, houses. You don't have to. I don't go into the details so much of jewellery and cars. Can if you want. I'm really focused on the homes, the family home and investment properties, and any shares or gold, silver, Bitcoin, anything you have, anything very valuable, transfer over to the Family Protection Trust. What the result is there's no capital gains or stamp duties. If you get sued, your net wealth is now in a trust, so it's protected. You do have to be careful who acts as trustee and appointer to ensure that nobody else gets de facto control of the trust, but we help you with that. It can afford family law protection, but the family law courts may look through it. What I mean by that is if you're already in a relationship that's on the rocks, you can't do this to get around keeping all your assets away from your current partner. It certainly may help you for future relationships. And it definitely helps your next generation. That's the most important thing. You get to hand your assets down to the next generation, and when they get married and divorced or whatever happens, however many times during their life, their partners cannot get the assets. That's 100% protected in the family bloodline. And for estate planning, it sits outside the estate. So what that means is that all of the assets are now in the trust for your life. When you pass, the assets just stay in the trust and pass to the next generation. That's how it gets around the death tax, because you're not transferring assets to any, like you're not dying and transferring assets. The assets are already transferred. Then they pass to the next generation, just staying in the trust. It avoids getting caught up in probate. It avoids a whole lot of complications for your beneficiaries, and it avoids the death and gift taxes. So just a quick example, and this is This is just a very common example. Client has, this is your average mum and dad, current market value house of 1.5 million with a mortgage of 500,000. My last client I spoke to just before recording this was pretty much exactly that situation. And 50% of our clients would be just very simple mum and dads with a situation like this. But let's say in 10 years' time, that property's worth 3 million, so it's doubled in value, which is quite common as well. They're both just on a standard salary of 100,000 a year. So some people of late have been very vocal in getting people to transfer their assets to a normal discretionary trust, or also they call it a private trust, which all discretionary trusts can be private. But these people were charging a lot of money and setting up trusts and getting people to transfer their home into a trust. I was very vocal saying, no, don't do that. And this is why. Because if you transfer it to a normal trust, there's stamp duty of 65,000. You'll lose your land tax exemption. So that's approximately 5,000 a year, 50,000 for this couple over 10 years. Worse, you lose your capital gains tax main residence exemption. So back to that property, which has now made over 10 years a gain of 1.5 million. It's now taxed at 337,500, and that's just 10 years. Imagine if this couple, if they're only in their 40s and they don't sell that property till their 70s, that tax could be millions of dollars. So this was always why I always said to clients, do not transfer your personal home to a trust. Total cost for that couple was 425,500 in taxes that they did not need to pay. Okay, not good. Let's compare that with the Family Protection Trust. No stamp duty, no land tax. You still get your full capital gains tax exemption. And if that's not enough incentive, let's look at the death taxes. So if the death tax comes in at 40%, same as the UK, that family home worth 3 million, taxed at 40%, is now saving $1.2 million. So now you can see why I am so determined to get this out to as many people as want to do it between now and when they announce these taxes. So just for this couple, the total stamp duty, land tax, capital gains tax and death tax saving is 1.625 million. And remember, this is just a 10-year strategy, just with an average mum and dad. I'm now working with clients that have millions and millions, and they're only young and they've got 20, 30, 40 years to go. This is a multi-million-dollar strategy for every Australian. Every Australian that has a property needs this. But there's more. So it's not only, and this is really important for what we call the tax anti-avoidance provisions, you cannot do something primarily to avoid tax. There are so many other benefits of the Family Protection Trust. As I said, these Family Protection Trusts have been around for a very, very long time. All of the elites use them. And this was before the death taxes are going to be announced. So there are very, very good reasons for doing it anyway. And that is that it shields the family assets from divorce and family law claims, bankruptcy and creditor claims, beneficiary misconduct and immaturity, which I'll talk about. So basically what it's doing is maintaining control and integrity of the family wealth, especially in high-risk professions or volatile relationships. It's also allowing for intergenerational wealth transfer. It enables the assets to be passed down without the stamp duty and capital gains tax if we do it properly. It's designed to hold the family wealth indefinitely across multiple generations of bloodline for family only. So this is about setting it up in your life to protect your kids and then your kids' kids and then their kids. So it only needs to be done once, and then the property can stay, not just the property, but the wealth. The property might be sold at one day, but the wealth can still stay in the bloodline and protect it forevermore. How many people out here have known someone who has inherited from their parents only to lose half of it in a relationship like that. Very, very common. So get this set up now for your future children and their future children and on. There's also protection from beneficiaries themselves. That sounds quite nasty. It prevents immature or vulnerable family members from accessing capital or control too early. So what I mean by that is, like, if we look at immature beneficiaries. So I personally don't think adult children should have the money until they're at least 30, maybe even later, because, well, now that my kids are getting towards 30, I think probably later, because I think if they got the money now, they'll just be buying themselves a Ferrari or doing some immature things. So I would prefer my family, all the wealth that I have built up over my life, to be held into a trust. They can use some of it. So you can set in your trust and in your guardianship documents for your future bloodline or your future children that, say, for example, they can have the income out of their trust to live on, but the capital gets protected. They could have money out for deposit on a home or 50,000 for a car instead of $500,000 for a Ferrari. Maybe they can have as much as they need for medical expenses or education expenses. So you can set the criteria when they can take the money but still have it protected so that they can't just take it all. And then vulnerable family members, more talking there, it's something that is very, very unfortunate, but the level of ADHD and autism in the generations coming through now is phenomenal. And so you need that capital protected so that whoever's looking after the money, being the executors or the guardians or whoever you have appointed to look after the money for vulnerable children, can really do that properly and make sure that they're looking after that vulnerable family member for the rest of their life. So your point of that is that the control of the trust and the money can remain with the trustee or the appointer or a guardian, so that the money can't be wasted. So the beneficiaries can have no fixed entitlement, which also helps them with marital disputes and Centrelink. So basically, there's just benefit after benefit after benefit after benefit. I do have said in my other podcast that I'm a very weird person, probably because I'm an accountant. Accountants themselves can be very weird. But I'm a particularly weird one because I've been really excited about only 3 things in my life. I had 4 children. I was a bit excited about them, but other than the children, 3 things in my life. And the first thing was testamentary trust, which I learned about in my early university career back in my 20s. I was very excited by testamentary trust and have been ever since. Everyone should have a will with testamentary trust. I won't go into that now. The second thing I was really excited about over 27 years ago was SMSFs. I didn't know what they were. When I got asked to be an auditor for SMSF, I had to Google what is an SMSF. And then I went, oh my God, this is better than sliced bread. And I got my children into my SMSF when they were only 3 or 4. And I have been an accountant and an auditor for SMSFs ever since. And then the third thing I've been excited about in life is these protection trusts. Because now we've got everything wrapped up. The will with testamentary trust for after the dead, this SMSF, which is the best way to invest money tax-free, and now the protection trust to protect the rest of your assets. So more benefits. It protects the assets against probate, which, as I've said, and I talk to people constantly, even a client just this morning, that her mother had a stroke and all of a sudden the chaos because she didn't have an enduring power of attorney. It's even worse if someone passes without a will, or even if they pass with a will that's not 100% drafted right. It can cause so many problems with probate. I have heard people's assets being locked up in probate for years. If you die without a will, your assets will be locked up by the state government and tied up for years and major fees. There's also the family petition claims and people contesting your will. It sits outside the estate, so there can be no claims or probate problems. So there's still even more advantages to these trusts, but I'm not going to keep going because I will just overwhelm you anyway. But all I can say, as I said, they're the Buckingham Palace of trusts. They're the most exciting thing I've seen other than SMSFs and testamentary trusts, these things would be on the same level as those two things that have excited me for very 20 to 30 years. So I've been involved in trusts, just to recap, for over 30 years. I've used them for clients with businesses, investment properties, but always advise people not to put their family home in one because of stamp duty, capital gains and land tax. But now we have a way to avoid these and even more reasons to do so as soon as possible. That's asset protection, generational wealth protection, and the death and gift taxes on the horizon. So the downside, as I've been saying, there is upside, 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 positives, 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 benefits, benefits, benefits. Of course, there has to be a downside. The downside is the cost. These things are not cheap, and I make no bones about it, because there is no point contacting me and getting me to talk to you or do a strategy paper for you or anything like that if you're not prepared for the cost, because they are expensive. The legal paperwork we're required to do to put this into place has to be 100%, and it's very, very complex for us. We're the ones that do all the complex work, but there has to be top notch. We have to dot every I, cross every T. Otherwise, it can fail in court. And there has been a court case on these trusts where it did fail, but it wasn't because the strategy was incorrect. It was because the paperwork was not correct. So it will cost between $10,000 to $20,000. $10,000 for a very simple mum and dad with one house. $20,000. I did a quote the other day for $40,000. Because they had multiple properties, but the client still went ahead because they realised the importance. Because when you look at the cost as a percentage of your net wealth, almost for every client, it's less than 1%, probably around about 0.5%. So is it worth paying 0.5% of your net wealth to now lock your net wealth in trust for generations to come? I believe it is. And there are ways of financing it if you don't have a spare 10 to 20,000 lying around. I also view it as an insurance policy. So if you think about how much you pay for insurance on your homes, your cars, everything. I mean, I particularly know that when I had a house before I sold it, the insurance premium was up to $6,000 a year to protect my house in case maybe it gets burnt down. What's the chances of my house getting burnt down? Very, very, very minimal. Yet most people still have house insurance just in case. Okay, so wouldn't you prefer to pay an insurance policy that protects all of your assets against all of these problems for generations to come with this cost, a one-off cost? Once it's done, it's in place forever. And remember the tax saving of 1.6 million. So once again, the cost is less than 1% of the tax saving. We do have 12-month payment plans for those that need it. That's difficult for me to do because I need to outlay all the money to get the strategy in place. And then if I get too many people take this option, I'm just way out of pocket. So that's only for people who really, really need it. We prefer to offer a finance option where you can get finance from an external firm and then you pay them off rather than us being out of pocket. But anyway, we can talk about that if you really need. We can also make a lot of the costs come out of your SMSF if you also have an SMSF will and other strategies. So anyway, how to get started. I don't do this for free because I don't have time. You email us and you can set up you can even just email us and just say, yes, I want a strategy paper. Or you can book in for an appointment with me where we discuss your situation and I tell you more. But then the next step is we invoice you 500 plus GST to get a strategy paper drafted. That is a personalized strategy paper for you and your family of everything that I think that you need to protect your family. It can include the Family Protection Trust, of course, but also wills, SMSF wills, enduring power of attorneys, board of guardians to protect your family going forward. For some people, it may also be upgrading your existing trust to a family protection trust. It can be making sure you've got proper succession plans on any companies and trusts that you currently run. It can be also moving some assets into SMSF or the trusts and how to minimise the capital gains tax on that transfer. It can be other strategies as well. So I'm willing to put basically everything I see in your situation. So my 30 years of experience in all things financial in a strategy paper for you for only $500. In realistic honesty, most accountants would probably charge $5,000 just for that strategy paper. But I don't want to do that because that will put people off. I will do it for $500, and then that price will even come off. So in that strategy paper, I outline everything that I recommend for you. You don't have to go ahead with it all, but you decide which ones you want, and the $500 will come off the price anyway. So you've really got enough. If you are going to proceed in, even if it's just a will, which everyone has to have, and an enduring power of attorney, you have to have that. So, and even if you've got an old one, it probably needs updating. So you've really got nothing to lose by doing the strategy paper, because that price will come off even if you just go ahead with your will. So to contact us, inquiries at Freedom FFS, and we will send you a client data form to get started. You can also just book straight in with us on our website. It's just that URL, freedomffs.com.au, where you can actually just book straight into estate and wills, estate planning. It's on there. It's a free appointment with me for 15 minutes. That's the easiest way to get started, or email us at inquiries@freedomffs. So I look forward to hearing from you, and let's get you sorted and get you protected before it's too late. Thank you all.